Tonight, our attention is on Buhari presidency, the rule of law and human rights. We will be talking to the Minister of Justice and the Attorney General, Abubakar Malami. And the House of Representatives Speaker Femi Gbajabiamila believes it's a failure of government if security situation is not fixed. We get details of his views as Parliament resumes plenary. Hello everyone and welcome to Politics Today live on Channels Television. I'm Sean Wakibaloye in Lagos. This is the midweek edition of the program, and so we shall be together for this 1 hour, and we'll take you through some of your biggest stories in the land. Tonight, we have the Minister of Justice and the Attorney General as our guest. Is in Abuja studio, Mr. Abubakar Malami, Senior Advocate of Nigeria. And the program will be focusing on the Buhari government, the rule of law and human rights. So stick around with us, everyone, as it gives us insight on what the Buhari government is doing in that regard. But first, let's tell you what is happening in your world of politics ahead of the November governorship election in Anambra State. The chairman of the Independent National Electoral Commission, INEC, is asking security agencies to replicate their conduct during last year's elections in Edo and Ondo states. Speaking at a consultative meeting with members of the Interagency Committee on Election Security in Abuja, the INEC boss stressed the importance of proper management of polling units in order to minimize disruptions. Take a listen to him.
The management of large crowds at many polling units across the country has been challenging to commission officials and members of excess, resulting in some cases in the late commencement of polls or the disruption of the sorting and counting of ballots at polling units. Such disruptions often have consequences on electoral outcomes, leading in some instances to avoidable supplementary elections. The Commission has already released the timetable for Anambra governorship election, scheduled to hold on the 6th of November 2021. I urge you to maintain the same level of professionalism displayed in the recent elections and ultimately the 2023 general election.
Thank you so much. You heard the INEC chairman there. But let's also tell you that at the resumption of plenary today, the Speaker of the House of Representatives, Honorable Femi Gbajabiamila, was speaking about the security situation in his opening remark when he's asking government to take responsibility. That is the responsibility of government to fix security, and it could be termed as a failure of government if that is not done. That was a position of the Speaker of the House of Representatives at his opening remark at today's plenary session.
Went on Christmas vacation. We will shortly begin considering bills to amend the Administration of Criminal Justice Act, and we will follow up with a long overdue review of the Trafficking in Persons Prohibition Enforcement and Administration Act and other legislation that seek to deliver a justice system that works for all. Every time a citizen going about their business is killed or kidnapped, loses their property or livelihood, we have failed in our obligation. From the abundance of these failures has emerged a culture of self-help in matters of internal security that portends grave danger for our nation's continued existence. If ever there was a time for us to put aside all other considerations, especially the petty concerns of partisanship and politics, it is now.
And let's tell you some party defection and party politics stories. Now, Chief Femi Fani-Kayode yesterday met with the national chairman of the APC and the governor of Kogi State, Yaya Bello. But what we are hearing today is that Mr. Fani-Kayode may have decided to leave the PDP for the APC. This is coming from the governor of Kogi State, Yaya Bello. Take a listen to him.
Our brother and friend, Chief Femi Fani-Kayode, has joined our party in good faith. For the youth. He is joining our party to come and add his own positive energy and make contribution into ensuring that APC is a party to beat. Remember, Chief Femi Fani-Kayode was a foundation member of this great party.
Well, you heard the governor of Kogi State, who incidentally is also the chairman of the Mobilization for Youth, Women, and People Living with Disabilities in the APC. But Mr. Fani-Kayode yesterday met with the national chairman of the APC and Governor Yahaya Bello, where he said they discussed the state of the nation, national issues, party politics, and the way forward. And sources are saying that the talks across party lines may become a defection story ahead of 2023. Well, that means they may not be far away from the truth. But Mr. Fani-Kayode himself had gone to Twitter, and this is what Mr. Fani-Kayode said on Twitter. He said, quote, "Though we have had meetings across party lines and we are in a season of political consultation, I have not left the PDP." Some readings in that tweet, isn't it? The story of defection might be true, but perhaps is not left just yet. So we'll see how this unfolds anyways. So let's get you some updates on some of the political stories that you need to know right now on our political roundup.
A federal high court in Abuja has ordered the Central Bank of Nigeria to unfreeze the bank accounts of the 20 EndSARS promoters. Justice Ahmed Mohammed gave the ruling following the agreement reached by parties in the suit to amicably resolve the matter. The judge, while commending counsel to the CBN, Mr. Michael Aunduaka, and lawyer to the defendants, Mr. Femi Falana, ruled that all processes filed in respect of the case are hereby deemed to have been withdrawn. Justice Mohammed then set aside the November 4, 2020 order and ordered that all the accounts of the affected persons be immediately defreezed.
Thank you very much. God bless you.
The chairman of the Southwest PDP Reconciliation Committee, Prince Olagosi Oyinlola, has stressed the need to reconcile all aggrieved factions in the party in order to avert defeat in future elections. The PDP chieftain stated this while fielding questions from newsmen after meeting with the members of the party in Ondo State. The chairman of the Southwest PDP Reconciliation Committee, former governor of Osun State, Prince Oyinlola, met behind closed doors with members and leaders of the party, and at the meeting held at the state secretariat of the party in Akure, the state capital, had in attendance leaders of the party at the state level and across the 18 local government areas of the state. However, the aggrieved faction of the party, led by the former chairman of the party in the Southwest Zone, Eddie Olafeso, did not turn up for the meeting. The Kogi State Governor Yahaya Bello has formally flagged off the All Progressives Congress membership registration and revalidation exercise in Kogi State. The governor went through the process in Okene with the charge that the youth across the country should participate fully in the registration process. Governor Bello was accompanied by his wife, the state deputy governor, Chief Edward Onoja, and other prominent political office holders in the state. In Kaduna, the APC says it is targeting 2 million new members in its registration and revalidation exercise. State Governor Nasir El-Rufai was part of the All Progressives Congress registration exercise as directed by the National Caretaker Committee of the party. Governor El-Rufai, accompanied by his deputy Hadiza Balarabe and some National Assembly members and other top government and party officials, were present at his Ungwa Seriki polling unit in Kaduna North local government.
It has become pertinent at this time.
And the Kwara State government has alerted the security agents and members of the public of the plot by some politicians to instigate violence in the state and later blame it on the state governor Abdurrahman Abdurrazak. The chief press secretary to the governor, Rafiu Ajakaye, made this known at a news conference in Ilorin, the state capital. Ajakai says those behind the plot cut across party lines, and the alleged plot is part of a grand conspiracy to defame the governor.
Thank you so much, everyone, for staying with us. So within the next few minutes, we shall be having a conversation with the Minister of Justice and the Attorney General of the Federation. Senior Advocate of Nigeria, Mr. Abubakar Malami, is in our Abuja studio. We shall be engaging him on the issues of rule of law and human rights under the President Muhammadu Buhari administration. Thank you so much, the AGF and Ministry of Justice, for your time tonight on the program. Let's begin the conversation from perhaps one of the biggest stories in the land, which of course caught the attention of the world when the hashtag EndSARS protest came about. The CBN took a decision to freeze the account of some of these young people. But the court today has asked the CBN to unfreeze the account. But as a federal government, and you are the legal advisor to the president and to the federal government, and you are the chief law officer of the federation, give us a sense of the decision of the federal government to make this move.
Well, Sheun, as far as the issue of human rights generally, not with a particular exception to the issue of perhaps the order of the court directing the unfreezing of the accounts of EndSARS protesters is concerned, the bottom line as far as the human rights position in Nigerian state is concerned is constitutional. Right to personal liberty, right to life, right to freedom of judgment, freedom of movement, and right to freedom of association, among others. And indeed, the freedom to own properties, movable and otherwise, is constitutionally guaranteed. But then, you must naturally strike a balance within the context of the sanctity of the constitutional human rights guaranteed. The point that calls for striking a balance is the fact that as an individual, where your right to personal liberty, right to life, right to freedom of judgment starts, it equally ends with perhaps excesses associated with violation of your fellow rights of the fellow Nigerian citizen relating to personal liberty, relating to right to life and freedom of movement. So in essence, it is not a right at large. We must have regard and respect to our individual limitations. The fact that you have a constitutional right to freedom of movement, right to freedom of association, right to life, does not mean, in essence, that you can as well violate the right of a fellow citizen. So it is about striking a balance, operating within a limit that you should not be seen in the exercise of your right to freedom of movement, right to personal liberty, right to life. You should not be seen as infringing on the right of others. That is where the striking, the balance component and element of it comes into play. Now, coming to the specific question with particular reference to the order of the court directing the unfreezing of the accounts of EndSARS protesters. Well, the court order is granted, but then you need to take into consideration a lot of other factors with particular reference to the compliance with the court order. And within the context of striking the balance, the options that are available to the government are multiple. One, a consideration or perhaps a possibility of wholehearted compliance with the order of the court without ado. That is comprehensive, unconditional compliance with the court order relating to unfreezing of the accounts. But that does not take away the right of the government to give further considerations when the need arises. A consideration, for example, of exercising the right of appeal against the order if the need for so doing arises, and coupled with the right of appeal, perhaps filing an application for stay of execution of the order, or perhaps an application for variation of the order, among others. Where the government have chosen to exercise those rights of appeal, and indeed filing an application for variation of the order, or indeed an application for setting aside the order or stay of execution, you cannot, within the context of the rule of law, adjudge the government as operating in breach. So what I'm laboring to state in essence is right to freedom of expression of, right to freedom, with particular reference to the right to life, personal liberty, freedom of movement, association, ownership of goods, movable and immovable, inclusive of the ownership of accounts, or perhaps compliance with the court order, is not a hook, line, and sinker arrangement. Associated with it are counter rights, which are equally rights that are guaranteed by law, having been rooted within the constitutional and statutory provisions of the law prevailing in the Nigerian state.
Is there any chance at all, because if you look at the outcome of today's court case, is there any possibility of an appeal of what came out of that case today?
Well, it all depends on the prevailing circumstances. For example, where parties unilaterally submit to perhaps a settlement arrangement, and the order of the court is a product of settlement arrangement, I think the possibility of considering options associated with appeal, variation of order, setting aside of the order may not necessarily come into play. But where it is indeed a product of contentions between the party A saying this is how it is, the other party saying no, this is the way it is, and the court now decides to make a ruling one way or the other, then the right of the parties to appeal, right to consider application for variation of the order, setting aside the order, or perhaps maybe staying the execution of the order may come into play. So it all depends on the prevailing circumstances. It is the circumstances that are prevailing that determines what decision, what position, what direction a party involved in the suit, or perhaps a party affected by the order one way or the other could consider what next line of action to take.
Honorable Minister, because of the optics of especially the critics of this government who believe that the decision of the federal government to freeze the account of these young people in the first place was an attempt to gag or to silence the voices of dissent in the country, or the rights of people to protest. And one would be wondering, what was on the mind of the federal government when it took this decision to freeze? Is it clear that there are security threats in their action?
Well, you see, the government is there to ensure that there are no security threats. And in so doing, the true position of things is that the responsibility of the government is to accord protection to the lives of the citizens, to their personal liberty, freedom of movement, and indeed accord protection to all the constitutionally guaranteed rights of individuals. So the government can on no account be forced to submission when protection of these rights are concerned. So a decision to comply with a court order or not is not a decision that is usually a product of intimidation. Government cannot be intimidated. Government cannot in any way be compromised as far as the exercise of its constitutional powers are concerned. But that does not mean to say that the government is perpetually inconsiderate. But then the bottom line is the public interest is what matters most in whatever decision government arrives at as far as compliance or non-compliance with the orders or judgments of the courts are concerned. So what I'm trying to say, in essence, intimidation is out of it, threats are out of it, and then the constitutionality is the bottom line.
All right, so we are due for a break, but I probably would like from the minister a yes or no answer. The outcome of today's order, does it not reveal that the government was perhaps wrong in the first place? Do you realize that maybe the government took a wrong decision?
Government is not wrong, particularly in circumstances that justify for extensive investigation. It is the end result of an investigation that can determine whether government is right or wrong, as determined by the court on the basis of facts as presented. So where you do not have a wholehearted determination of an issue, then certainly, inclusive of going whole hog up to the point of the Supreme Court, you cannot rightly conclude on that position.
All right, Minister, we'll take a break, our first break on the program. But when we come back, we dig more into the issues of human rights and rule of law under the President Buhari administration. Please stay with us. Everyone, we'll be right back. Thank you so much, everyone, and welcome back to the program. Let's continue our conversation with the Minister of Justice and the Attorney General, Mr. Abubakar Malami, Senior Advocate of Nigeria, who is our guest on the program from our Abuja studio on the issues of human rights and the rule of law. Honorable Minister, let's get started again. And I'd like to know the records of the Buhari government. A lot of your critics will say that it's not been so good. But let me ask you, are you satisfied with the human rights records of the administration in which you are serving? I'm asking this question because of cases of human rights violation by agents and agencies of government, including the police, DSS, the military, customs, and several other agencies. What have you done as the AGF to curb these violations and bring perpetrators to justice?
Well, I think in assessing the human rights records with particular reference to violation of the government of President Muhammadu Buhari, the proper index to determine whether we have indeed lived up to expectations or not are the international records, among others. Let me, for example, begin by referring you to the report recently released of the International Committee for the Protection of Journalists. This is the first time ever the coming in place of Nigerian state in existence that Nigeria is taken out of the index of violators of rights of the press with particular reference to freedom of expression. And I think, considering the volatility of relationship nationally and universally between the government and the journalists, with particular reference to the lack of harmony as far as the relationship is concerned, a state, or perhaps indeed a nation that achieved a feat of having itself taken out of violation index by international community for the protection of journalists, goes indeed to establish the fact that Nigeria, under the leadership of President Muhammadu Buhari, has indeed done wonderfully well as far as the index of human rights compliance is concerned. And that, you rightly agree with me, prevails all over, not only as it relates to relationship with the press and journalists, but as it relates to the rights and indeed the protection of the rights of the citizen. Again, taking you back home with particular reference to the human rights posture of President Muhammadu Buhari, I think, and I am certain, that the administration of President Muhammadu Buhari was the first administration ever in the history of Nigerian state that has given effect to the recommendations of the National Human Rights Commission, with particular reference to the settlement of certain financial recommendations made as it relates to APO 6 for that matter. So the National Human Rights Commission has over time been a toothless dog as far as application and compliance with the recommendations are concerned, and the government of President Muhammadu Buhari has given effect to such considerations. Perhaps, maybe, I think the government of President Muhammadu Buhari has been very and indeed extraordinarily lenient with the human rights protection, and that was indeed what caused the problem associated with the violations of the EndSARS protest. Take, for example, no nation in the world could have tolerated a situation whereby over 200 of its policemen were killed in the process, in the purported process of expression of freedom of expression. Nigeria has tolerated that. No nation in the world could have tolerated the idea of destruction to its security institutions. I think over 20 police stations or more, I'm not certain of the number, but certainly they were multiple, were destroyed in the course of EndSARS protection. And the government has a responsibility in the circumstances to ensure protection to lives, protection to personal liberty, protection to freedom of movement and of individuals. And here we are confronted with a situation whereby EndSARS protesters blocked roads, caused mayhem, caused death, caused destruction, and they were significantly tolerated to a certain extent. And I think, in all sincerity, against the background of these facts and figures, facts relating to international rating, facts relating to local tolerance of the excesses of the EndSARS in breach of constitutional order, I think it is only logical for one to conveniently, logically, and justifiably conclude that the government of President Muhammadu Buhari has shown greater zeal in terms of protection and indeed giving accommodation to human rights, and to the extent of perhaps accommodating the excesses, which ordinarily ought to have been indeed confronted squarely. So I think as far as the human rights record of the government of President Muhammadu Buhari is concerned, the fact speaks for itself. International commendation by the international body, which is indeed the Committee for the Protection of Journalists, local compliance with the recommendations of a National Human Rights Commission, which has been unprecedented, tolerance and indeed accommodation of the excesses of the EndSARS protesters were all facts that goes to establish a point that the government of President Muhammadu Buhari has shown greater accommodation of the human rights violations and the tolerance to human rights, to the human rights record as far as the Nigerian state is concerned.
Well, if you look at some of the reactions that we've gotten in the land over some of the decisions of the federal government, perhaps are opposed to some of the position that you've heard, Honorable Minister. And looking at the report of the Committee for the Protection of Journalists that you have listed, as also, as early as this year, that committee has listed a few of violation of rights of journalists in Nigeria. But if you put that on one hand, on another hand is the decision of the federal government, that the president specifically, in extending the tenure of the Inspector General of Police, considering Section 17 of the Constitution, Section 5 of the Constitution. These are provisions that clearly dictated how the president should act in that regard. But if you look at it, also, the not securing the confirmation of the new service chief before appointing them as prescribed by the Constitution and the Armed Forces Act, but choosing to appointing them and belatedly in an post-facto fashion seeking a retroactive confirmation. So, Honorable Minister, how do you defend the decision of the president in extending the tenure of the IG as against the position of the Constitution?
Sheun, I think you are mistaken and indeed greatly misconceived as far as the position of the law is concerned. The question you put across is a question of mixed law and facts. It's not a question that you can simpliciter answer without recourse to facts. You must have factual foundation on the basis of which the law can come in place for the purpose of ascertaining the answer associated with the question. How do I mean, Sheun? If you are talking of an extension of a tenure of an IG, or perhaps Inspector General of Police, first thing that you need to be certain and sure of are the official records relating to perhaps his date of birth, official records relating to his service period, official records establishing when he joined service, when he is due to retire, official records establishing the communication of the termination of his, term in office, communicating same to the president, official record establishing when the president has taken steps or action over the notification of time, the tenure of the Inspector General of Police. Without you presenting to the public this incidental and associated official records establishing this factual background, the law relating to the constitutional provisions you have cited with particular reference to the tenure in office of the Inspector General of Police can certainly not be answered judiciously, effectively, and legitimately. So my question, perhaps to you, or a poser to you, Sheun, is provide these records for me, factual records, factual official records, so that there could be the basis for me to answer your question. If you do not have these confidential, factual, official records, it will be premature for me to answer your question because it amounts certainly to guesswork, divide of factual foundation on the basis of which the question can justifiably, logically, sufficiently, and factually be answered. So my position is clear that your question is built on assumption, suspicion, and devoid of official facts, and indeed cannot be effectively answered. That conclusion is erroneous. That conclusion is premature without you doing your homework and perhaps maybe getting the official records on the basis of which you can now apply the law for you to arrive at a conclusion. My answer is Mr. President was very well guided as far as that decision is concerned, and that can only be established by official records of the government. And I am sure you are building your question on the basis of assumption and not on the basis of facts, and much less of official facts for that matter.
Okay. Honorable Minister, it's interesting that you're talking about facts, and we love that you can educate Nigerians, because the purpose of this conversation is not about me, it's about putting the facts out there and clarifying some of what Nigerians are worried about and the decision of the president. For example, the law specifically talks about the age in which the year of service of a police officer. From the record that we have, if there is another record that is against what is publicly known, we would like you, Honorable Minister, to clarify. The record that we have is that the IG, Mr. Muhammad Adamu, joined the force on the 4th of February, 1986, which stipulates that on the 4th of February 2021, it would have exhausted the time as stipulated by law to have ended his stay in office as a police officer. Is there anything against that from the official records provided to the federal government, Honorable Minister?
The president has acted within the stipulated, regulated, and constitutional time frame as allowed by law. That is the best I can put in the public domain within the context of need to know basis. The position of the law is there is a time frame, constitutional time frame, within which the president is expected to act, and the president has accordingly acted within the stipulated, regulated constitutional time.
Honorable Minister, please, can you clarify the record I just read out? Is it different from what the government has?
I am talking of time within which the president is expected to act with the record, with the stipulated record you are making reference to, and I'm telling you the president has acted timeously and indeed has acted within the regulated time as stipulated by the Constitution, with particular reference, with factoring to mind the fact that Mr. President has to act for the purpose of extension at a time when the IG remains a police officer within the context of the law.
So clarify for us again, because you're a senior advocate of Nigeria, your years of service, and the Attorney General also. Maybe there are some things that we do not know that you need to also inform Nigerians about. Lawyers have debated that as it stands, that the Inspector General of Police is a retired police officer. Is that true?
Lawyers have debated outside the factual situation without being abreast and fully abreast with the position as it relates to the time within which the president was expected to act and within which the president has acted. So if a lawyer is not indeed in custody, is not in position of correspondence establishing the time within which the president has acted, I think that argument is baseless because the factual circumstances, factual foundation, and factual information that he requires that could have been the basis of his arriving at a decision one way or the other were not at his disposal. So a lawyer that argued without official correspondence establishing the sequence and circumstances of the actions of the president, when the actions were carried out, what happened, and then what the prevailing circumstances, was indeed a baseless argument that is not rooted in facts in respect of an issue over which you require facts for you to act. So acting in vacuum, devoid of factual situation, devoid of official correspondence, is indeed an argument that is baseless because the factual foundation required for the application of the law are not at his disposal.
So, AGF, give us an understanding. The portion of the law you're talking about, is it the Constitution or the amended Police Act of 2020? Upon
you
which
have
of these
cited
laws?
the provision of the Constitution. When you have cited the provision of Section 7, Section 5 of the Constitution. And when you talk of the Constitution, any ancillary legislation, any associated legislation inclusive of the Police Act does not come into play. What I'm saying, as far as that constitutional provision is concerned, it's not a provision that can act in vacuum, that can be cited in vacuum. Is a constitutional, the provisions are constitutional provisions that must be rooted in facts. And that fact, as far as the tenure of office of the IG and the time within which the president is expected to act, with particular reference to the extension of tenure, are all factual situations that you require certain and confirmed factual position for you to be able to answer, to give accurate and ascertained answer to the application of the law. So a lawyer that is not indeed in possession of those facts and circumstances must have perhaps based his argument on a foundation that, on a baseless foundation. So what I'm saying in essence, within the context of official records, within the context of the action taken by the president in terms of extension of tenure, the necessary compliance with the law has been consummated, and the president worked and indeed acted within the context of the law with particular reference to the timing, with particular reference to the consideration of the law as it relates to tenure extension of the Inspector General of Police.
So what about the service chiefs? In that regard also, the argument out there that that perhaps should have gotten, the president should have written to the National Assembly before making the appointment, should have been confirmed before the president make an appointment.
Well, when you talk of an appointment, you should be guided by the fact that the Constitution vests the power in the president to make the appointment. Well, the component relating to confirmation of the Senate is there. So the Constitution has not taken away the power of the president to make an appointment, but then has equally recognized the component, the element of confirmation by the Senate. So the appointment is something that the president is constitutionally vested with the power to do, and then referral to the Senate for the Senate to do the needful is equally considered by the Constitution. So the appointment component, the simple question arising from the Constitution is whether the power is vested in the president for appointment. Yes, the answer to the question is clear and concise. Yes, the president is invested with the power to appoint. The president has now appointed. What is it that is further expected of the president of an appointment? Processing them same to the Senate for confirmation. So the appointment, the power to appoint vests in the president and he has exercised it, the power to confirm is vested in the legislature and same has been transmitted to the legislature. So the fact remains that he has the constitutional power to appoint and he has appointed. The fact further remains that the appointment should be passed on to the Senate for confirmation and it has been confirmed. So these are two distinct and separate things. If at the end of the day, the appointment is not confirmed by the Senate, so it doesn't stand. So the appointment, right to appoint, is constitutionally vested, but then is contingent on the confirmation of the Senate. If the Senate confirms, so be it. If it doesn't confirm, then in essence, that means in essence, Mr. President has to reconsider the appointment. So that is the true position of things.
All right.
So if the President now intimates the Senate that I have appointed so person, is because the Constitution is direct, positive, and clear that he can indeed appoint. But then what? What happens after the appointment? Pass on to the Senate for confirmation. So the language of the Constitution is not that the President must have the Senate confirmation before appointing. The President can appoint. The operative word that is considerable within the context of the Constitution is that the President can appoint, not that the President can only appoint after confirmation. Appointment comes first, confirmation comes next. That is the language of the Constitution.
All right.
It doesn't say that the President cannot appoint without confirmation of the Senate. So it is indeed an order of hierarchy within the spirit and context of the Constitution. Appointment, confirmation. It doesn't say confirmation and appointment. So I think that is where the misconception is. The language of the Constitution tolerated the action taken by the President, which action is that the President appoint and then confirmation of the Senate is required.
Okay.
If
Honorable
the
Minister.
language of the Constitution is that the Senate confirms and then the President appoint, that in essence means the President can only appoint when eventually the process of appointment is concluded by the Senate. But the language of the Constitution is appointment first, confirmation next. So I think within the spirit of the language of the Constitution, the President has acted rightly.
Let's take another break, Honorable Minister. And when we come back, there are other aspects of the rule of law and your office that we need to clarify and get some information from you. We'll take a break now. Join us again, everyone. Thank you so much, everyone. Let's continue with our conversation with the Honorable Minister for Justice and the Attorney General of the Federation, Senior Advocate Abubakar Malami. Thank you so much, Mr. Malami, for your time now. Let's get into other matters. You have perhaps heard or read the Transparency International report, which mentioned part of the report that was released was the interference in the operations of the anti-corruption agencies. And we will look at also what the issue of for example, the committee led by Professor H.S. Sage, and that the accusation or the argument that the anti-corruption war has been dismantled. The Sage-led Presidential Advisory Committee Against Corruption does not have any flattering view. What do you say about the alleged role in whittling down the anti-corruption war?
Sorry, Sheon, can you please come again?
All right. So there are, in the Transparency International report, there are accusations that there are interferences in the corruption fight. And if you take that vis-a-vis what is happening with the Professor H.S. Sage-led Presidential Advisory Committee Against Corruption, and a lot of people who have said that, look, it does not have that power. The power has been whittled down. And it comes to the point that, does it buttress what the Transparency International has said about the fact that the anti-corruption war has fallen flat on its face?
Well, it depends on the variables that were taken into consideration by Transparency International in arriving at that decision. But regardless of the circumstances, the empirical facts on the ground does not support the conclusion of the Transparency International And as a government, we have taken steps to join issues with them because we have gone through the report, and our conclusion arising therefrom fundamentally, with particular reference to fundamental issues, was indeed that the report was not comprehensive, the report was not factual, the report was baseless. Now, let us consider the report from the perspectives of the recorded convictions, for example. Ever since the establishment of the EFCC, Economic and Financial Crimes Commission, the Commission, there was no year that the Commission has recorded many convictions compared to the period it was established to the present time than the year 2020, among others. The number of convictions recorded by EFCC had indeed surpassed all the previous performances with particular reference to convictions. So if what matters in the fight against corruption is conviction of the erring people, for that matter, then certainly the report of Transparency International in that respect cannot stand the test of time. Now, coming to the ICPC, for example, if what matters to Transparency International is the deployment of, preventive measures, ICPC has for the first time recorded a tremendous success as far as putting in place preventive measures that prevent corruption is concerned. If you take, for example, what the ICPC is doing in terms of tracking the execution of the project, following the trails of money within the governance cycle, for example, for that matter, we have never had it so good in terms of preventing corruption and corrupt practices, taking into consideration what this institution is doing. If you are equally considering the performance of the government with particular reference to the code of conduct as it relates to investigation, as it relates to conviction, as it relates to ensuring the declaration of assets by public officers, we have never had it so good within that context. If you are talking of the international recovery of funds, for example, the government of President Muhammadu Buhari has succeeded in recovering monies internationally that were brought back, monies that were looted before this government comes in place and then repatriated in 2020, among others. At a go, we have succeeded in repatriating over 311 million US dollars from America, arising from corrupt practices. And this money was indeed not only brought back home, but were indeed being applied in the second Niger Bridge, being applied in the construction of Lagos-Ibadan Expressway, being applied in the construction of Abuja-Kano Expressway. So by whatever parameter, within the context of the fight against corruption, you look at the Nigerian performance, I think it is out of place for the Transparency International to arrive at that conclusion. So, but then one point that I think is clear, the obscurity associated with the parameters of the Transparency International with particular reference to the conclusions it reached. Looking at the report, those parameters on the basis of which they have indeed arrived at their conclusion are not visibly there. More so, when you now consider our ranking with particular reference to ease of doing business, the Nigerian rating has gone high. So it is illogical, incomprehensible that you have a ranking, international ranking, with particular reference to the transparency of processes, and you equally have multiple convictions, much more than any other period, comparatively taking into consideration preventive measures in place, and over and above the fact that internationally our performance was recognized on account of which we were brought back to Egmont Grove that we were at a point expelled, and yet Transparency International arrived at that conclusion.
Yeah,
but so for your information, we have indeed taken steps to squarely challenge the conclusion of the Transparency International and join issues with particular reference to that report. We are not folding our arms. It's a report that, to our minds, taking into consideration these listed variables, it is our position that that report is misplaced. We are not taking it. We'll challenge it and we'll join issues accordingly.
All right. So we need to close the program now because we are out of time, Honorable Minister. But there is just 2 short questions which we need to deal with in just 60 seconds, if you can help me, Honorable Minister. And a very important one is that we need an update on the investigation of Mr. Ibrahim Magu, the EFCC acting chairman. What is the outcome of that report?
Well, to my mind, to my understanding, the report is a work in progress. The committee has been put in place by the president. Committee has rounded off its investigation and submitted a report to the president. And the president is naturally expected to take his time into looking at it with particular consideration of incidental steps to be taken. Maybe perhaps the president may consider the possibility of having a white paper committee, but it all depends on the discretion of the president, taking into consideration that it is indeed a presidential committee. So perhaps maybe thinking aloud as to what possibilities are there, but then I think arising from what is ongoing is a work in progress.
All right, so let's close now. And this very one, you help me just in 20 seconds. Have you seen your posters of you wanting to become governor? It's around town. I'm very sure that your aides may have told you about it if you have not seen it. What's your political plan? You want to be governor in 2023, Honorable Minister?
My political plan is to remain actively in politics regardless of the context for a political office, elective office or otherwise. I am a politician, a private legal practitioner, and I intend, and a businessman for that matter, and I intend after my stay in office, after my tenure in office, to continue such engagement politically, legally, and indeed business-wise.
Honorable Minister for Justice and the Attorney General of Federation, Mr. Abubakar Malami, Senior Advocate of Nigeria, thank you for coming. But there is a whole list. I have almost 10 pages of questions that I would like to engage you with. But I do hope if you can give us a commitment that you will promise to come at some other dates that you agree on. Can we take that promise, Honorable Minister?
I have it on record that I have never turned out an invitation by channels, and I will continue to stand by that commitment of honor.
Thank you so much, Honorable Minister, for coming tonight. I appreciate it. That's our show for tonight, and the conversation will be the Honorable Minister for Justice, Abubakar Malami. Thank you, everyone, for watching. I'm Sean Kimale. Bye-bye.